Greetings. This is Professor Welch, and this will be part one of various recordings on business law. I've taught business law for many years, since 1981 to 2007. It's one of my favorite courses. It led to my tremendous interest in going on to law school. There are many subjects such as torts, criminal law, civil procedure, constitutional law, contract law, and many other subjects that are taught in a business law course. In terms of basic concepts, we'll be going over those today. Our first concept is precedent. Courts tend to decide things as they've always been decided. And what happens is sometimes they overturn precedent, but it's very slow to do that. For example, Brown versus Board of Education overturned the precedent in Plessy v. Ferguson, but that took about 100 years to do that. So that's how the law develops. And now certain cases are handled in the federal court system. We have a state and a federal court system in the United States. And the federal system requires a case to have diversity of citizenship and more than $75,000 in dispute. And what happens if we have a resident from Pennsylvania and a resident of New York, and the dispute has to be more than $75,000? A teacher might put exactly $75,000. That would be false because it's not more than. Now, torts are a civil wrong for which the court will give a remedy. There's torts to property, and there's the intentional torts, such as, I call them BAFI, B-A-F-I, battery, assault, false imprisonment, and intentional infliction of mental distress. And then there are torts to property, and I call it TCC, trespass to land, trespass to chattel, which is just a minor interference with property. You may have sat on someone's hat and did some interference. Conversion C is a major interference with someone's personal property. And then looking at torts, we have intentional torts, we have negligent torts, and then we have strict liability. And in the negligent torts, there's a concept of res ipsa loquitur. That means the thing speaks for itself. That's a Latin term. A mouse in a Coke bottle is an example of the thing speaks for itself. The mouse didn't get there unless someone was negligent. And then we have the Fourth Amendment of the Constitution that protects an individual from unreasonable search and seizure. And the Fifth Amendment, meaning you do not have to incriminate yourself out of your own mouth. You don't need to incriminate yourself. Also important in terms of understanding basic concepts of business law is the burden of proof. In the criminal case, it's beyond a reasonable doubt. There may be a doubt, but is that doubt reasonable? Johnny Cochran in the O.J. case said it's beyond all doubt. Well, that would be incorrect. Is there a doubt when they're running to the border with a disguise and $10,000? But is that reasonable? And then a civil case is preponderance of evidence. Think of the scales of justice, and suppose one scale is balanced 51%. Well, then they've met their burden of proof. 50 to 51% has to be over 50%, like a feather on the scale makes it go over. Now, in terms of the Constitution, the federal government gets their power from Article 1, Section 8. And so when the head of Congress goes to bed at night, he tucks Article 1, Section 8, to coin money, to regulate commerce, under his pillow. That's where his power comes. The states get their power from the 10th Amendment. So Governor Gavin Newsom would tuck under his pillow the 10th Amendment for health, safety, morals, welfare. The mnemonic I use is, "Who stole my wife?" Now we look at battery. Here's a question. There must actually be physical injury involved in a battery. That's false. It has to be a harmful or offensive, intentional touching of the person of another or something closely associated with them. So we've talked about conversion. Here's a question. Intentional and unjustified interference with another's personal property or with that person's right to use his or her property is known as conversion. That's a substantial interference. You ripped up the hat. You didn't just sit on the hat. Now let's take another question. D deliberately runs a stick through the spokes of the wheel of the bicycle P is riding. P does not fall from the bike, but and was not touched or thrown by it, but something closely associated, meaning the bicycle, was touched. Is this a battery? That's true. Or if he held an umbrella and they hit the umbrella, that would be the battery. So what we need to look at is the various types of torts action to review. Negligence, which is carelessness, failure to act as a reasonable person. Intentionally, there's intentional torts, intentionally causing an injury. And strict liability, that's a wild animal that gets out, a snake gets out and bites someone. That's strict liability, mean absolute liability. Many of the terms in law are Latin, such as stare decisis, meaning let the decision stand. And that means the tendency of the court to decide things as they've always been decided. Now going on to other questions. Voir dire, that's a process of discovery. That's not a process of discovery. What that is where a jury is selected and they ask questions of jurors. Often it's through written questions and through oral questions by the attorney and the judge. And what happens there is they select or excuse people who they don't want. For example, I was called to jury service, but I was excused along with a Buddhist priest because they didn't think that we would be good on a jury involving a police case. So that's how the jury system works. The first step to be taken in a civil lawsuit is to file a complaint. And you go to the court and you file the complaint, and then it has to be served. And then it's like a tennis match. They may bang up an answer, or they may do a motion to dismiss or some other motion. Now we need to talk about misdemeanors. Misdemeanors are less serious than a felony. Crimes are either misdemeanors or felonies. Misdemeanors are punishable in state prison less than a year. Felonies are punishable in prison for a year or more. In law school, we learned another mnemonic, barroom, B-A-R-R-M-M, for major type felonies. B is burglary, A is arson, R is robbery, R is rape, M is murder, M is mayhem. That's a permanent disfigurement of another